Thanks for joining our speaker event this evening, Smoke Claims and the Way Forward. This is an EFRU and LA Standing Homes event, and we're excited to have Kevin Pollack here of ACTS Law to share with us the presentation that he made to the California Smoke Claims and Remediation Task Force on behalf of the policyholder. EFRU is a resident-led advocacy group collecting and mapping industrial hygienist test results from homes in Altadena, Pasadena, and Sierra Madre. We continue to need your tests, so please do send those in. It includes now post-remediation tests. And so even when your post-remediation tests come in clean, and especially if you have submitted the pre-remediation, it's really helpful for us to be able to have that data and so that we can map it and get the full picture of how remediation is going. My name is Krista Copeland. I am a founder of the Surviving Structures EF Recovery Facebook page and one of the founders of LA Standing Homes. Dawn Fanning of EFRU will be moderating the Q&A for us this evening. We are joined by someone who is translating hygienist reports, lab findings, and building science into legal accountability in the courtroom. Kevin Pollack leads ACTS Law's insurance bad faith litigation practice and has become a champion for wildfire smoke victims. He brings science into the courtroom using hygienist testing, lab analysis, and building forensics to prove contamination and force insurers to keep their promises. As lead counsel in numerous cases against insurance companies like Allstate and National Surety, Kevin has obtained groundbreaking rulings this year, exposing shallow investigations and demanding that insurers return people to safe homes and thriving businesses. Kevin, thank you so much for being with us, and I'll now turn the meeting over to you.
All right. Well, thank you so much for having me. I'm really excited to do this presentation. This is something that I'm very passionate about. The presentation tonight is Smoke Damage and the Path Forward. I'll be presenting today sort of background about what we're facing, what all of you folks who have standing homes who've been contaminated by smoke, soot, ash, and all of the various contaminants within there. I'll be talking about the law and the context, and what I believe is a systematic crisis in how insurance companies are handling smoke damage claims. This isn't really speculation. It's documented by the San Francisco Chronicle, by the New York Times, by the LA Times. It's documented in court filings. It's documented in the Department of Insurance Enforcement actions, complaints that many of you have filed. And this is what we are dealing with today. California law requires insurance companies to cover all loss by fire, including smoke contamination. The Department of Insurance has confirmed this, and courts are enforcing. But thousands such as yourself remain in contaminated homes because insurance companies are systematically violating their legal obligations. Let me start with what makes this crisis different from any wildfire disaster California's faced before. Traditional wildfire smoke comes primarily from burning vegetation, such as trees, brush, and organic materials. But urban wildfire smoke is fundamentally different. When the Palisades and Eaton fires tore through neighborhoods, they didn't just burn trees. They vaporized entire homes, vehicles, electronics, appliances. They burned plastics and lithium batteries, treated lumber, synthetic building materials. The result is a toxic chemical cocktail unprecedented in wildland fire history. And the Department of Insurance itself acknowledged this in February 2025 in a notice, citing asbestos and heavy metals and chemicals and other hazardous substances posing significant threats to health and safety. That's right. The Department of Insurance, approximately a year ago, told everybody that the hazards contained in wildfire smoke posed a significant threat to health and safety. Despite the insurance industry spin that I'm sure all of you are facing, this is not an exaggeration. For every home destroyed, another home was left standing, but steeped in smoke contamination. And in the LA fires alone, that's an estimated 13,000 homes within 250 yards of burned structures. As you all know, your homes look intact from the outside, but families are being told that they can return, despite the fact that no one has verified whether the homes are actually safe. The crisis is systematically invisible. The homes look safe while containing hazardous contamination. And this is perhaps the most damning evidence of what's actually happening. The Eaton Fire Residents United data reveals that of 45 homes that had undergone remediation, 43 out of them still had unsafe contamination. That's 96%. And let me give you one example that was covered, I believe, by the New York Times, or possibly the Chronicle. The Van Ness family in Altadena. Farmers Insurance approved $25,900 for professional remediation. Farmers hired their go-to vendor to test the house after the remediation and told them that the hazardous stuff inside the home was, quote, below threshold and that the family needed to move back. So that's what the Van Ness family did. But after moving back, Mr. Van Ness claimed he didn't feel right. And then independent testing revealed lead at 27 times the federal limit in the kitchen, 7 times the limit in the dining room, and 8,000 micrograms per square foot in their HVAC system. Further testing revealed the children had heavy metals in their hairs when they tested the hair. The insurance company told the Van Ness family to move back, but it wasn't safe. This pattern of manufactured scientific uncertainty is not new. We've seen it before with tobacco, with asbestos, with lead. The New York Times interviewed David Michaels, the former OSHA administrator under 2 different administrations, and he reviewed the insurance industry's approach and called it, quote, absolutely the latest integration of science for hype. And the playbook is identical. They fund studies showing that the methods are safe. They cite non-peer-reviewed research. They attack independent science that questions their methods. They manufacture doubt about severity, and they deny proper action by first claiming no standards exist, and then they create self-serving standards. The insurance industry is deploying this exact playbook, and they are using it to deny smoke contamination victims such as yourselves the funds that you need to properly restore your homes. And let me give you a specific example of the science for hire in action. So farmers cited a person named Dr. Wade and his so-called study to support why the Van Ness family needed to move back to their home. Dr. Wade's so-called study has been cited by farmers multiple times and other insurers to justify denying remediation. Dr. Wade works with a very well-known remediation company that insurance companies hire called Safeguard. But when examined closely, it turned out that Dr. Wade's so-called study was never actually published in any peer-reviewed journal. It was never subjected to scientific scrutiny. And Dr. Wade himself, when interviewed by the New York Times, acknowledged that it was merely his own research summary. David Michaels, who has spent decades studying corporate manipulation of science, reviewed this, and he concluded that the report is not objective science, that it's simply another example of science for hire. You aren't losing your claims because the science is unclear. I want to be clear about that. That's not why you're struggling with your insurance companies. You're struggling with your claims because the insurance industry is deliberately obscuring the science. So now let's talk about how the tobacco playbook is being implemented specifically with respect to smoke claims. Right after the San Francisco Chronicle article came out in the beginning of December, citing and talking about the smoke claim remediation task force from the Department of Insurance and calling into question those members on that task force, 3 restoration industry trade organizations came out with this new guideline in December of 2025. So you had the IICRC, the RIA, and the CIRI published a brand new, quote, technical guide for wildfire restoration. And I want to talk and walk you through 3 things that really undermine and show the problems with this document that they prepared. So number 1, the motive. Okay, so if you were to go and look up this IICRC technical guide, you would see on page 3, there's a foreword. They have a foreword right at the beginning where they explain their motivation for preparing it. Okay, and I'm gonna quote from it because I think it's really important to show where these people are coming from. Quote, "It has come to the attention of our organizations that a growing unfounded sentiment is emerging, suggesting that homes affected by wildfire smoke and its byproducts are categorically uncleanable and unrestorable. According to this viewpoint, wildfire-damaged homes should be stripped down to the studs and rebuilt. In our view, this position is unsupported. So, before presenting a single piece of evidence, the document announces its conclusion. Comprehensive restoration is unfounded and unsupported. Is that how science works? You announce your conclusions before your analysis? Well, I'll tell you, from my experience, that's not science, that's advocacy. The verdict came first, the trial came second. What's also telling is that on pages 23 and 24, they identify who the authors are. They call themselves the Wildfire Joint Task Force, except that the authors are entirely made up of insurance industry consultants, insurance industry defense experts, and vendors who serve insurance companies. All 8 have documented ties to the insurance industry. Now, what's missing? No independent toxicologists, no consumer advocates, no independent health experts. Not one voice whose professional role is protecting families rather than defending the insurance industry perspective. So when evaluating any document, the question isn't just who wrote it, it's who didn't and why. When you turn to the bibliography of this document, their support falls apart like a house of cards. You have the authors citing their own prior work. Trade journals published by the same organizations that published the very guide. No peer-reviewed scientific research, no toxicology studies, no environmental health data, and no engagement with post-restoration testing results. The EFRU came out with the post-restoration testing results in the middle to the end of 2025. They refused to engage with that data whatsoever. So we have real-world data showing that insurance-approved restoration is not working. We have evidence of exposed families and evidence of children with neurotoxins in their bodies. Homes retested with lead. And not only finding lead, but levels exceeding even federal standards. Where is that in that industry guide? It's not there. Because when you're writing a document to defend industry practices, you don't cite the evidence that those practices are failing. So to provide the full context, we have to step back. You have a conclusion announced before the evidence. You have authors with financial ties to the industry who benefit from their conclusion, and a bibliography that's a closed loop, and the deliberate omission of data that contradicts the predetermined outcome. The tobacco industry did this. They funded research designed to reach favorable conclusions, published it in journals they controlled, and they called it science. And this is exactly what the insurance industry is doing now. The difference is transparency. You can read this document for yourself. Don't take my word for it. Go and look at it. The question is whether this is the science we're going to rely upon to decide if California families are safe in their homes. And this is why we are here. This is what the industry is doing right now. Step 1, your homes appear intact from the outside, so there's no visible catastrophe. Step 2, invisible contamination permeates the walls, your HVAC systems, your soft goods, and building materials. Step 3, the insurance industry tells families to return home after minimal surface cleaning. They recommend the very basics. I'm sure you've all been told, all we need to do for your home is some HEPA vacuuming, some wet wiping, and throw some hydroxyl for deodorization, and we will call it a day. The problem is, no one actually verifies whether your home is safe for habitation. Step 5, your claims are closed, your ALE is terminated, and you are left unknown without certainty if your home is safe. And this isn't a failure of your individual adjusters that you're dealing with. It goes much higher. This is a systemic pattern of conduct. Now, let's be clear about what's at stake. Thousands of you are affected. Children, immunocompromised, elderly, and everyday people are being exposed to these contaminants: lead, beryllium, asbestos, and others. Homes are contaminated with known carcinogens, and an entire industry is systematically denying coverage that California law mandates. Now, none of you are asking for special treatment. You're only asking for what California law already requires. It's called all loss by fire. The law is very, very clear on this, despite what the industry tries to tell you. So let me show you. We now turn to the legal framework, specifically Insurance Code 2071, which mandates coverage for all loss by fire. It's not a novel theory. This is not an aggressive interpretation. In fact, it's based upon 130 years of settled law that insurance companies are now trying to circumvent. So let's back up and talk about the historical context. In 1906, after the San Francisco earthquake and the resulting fires, insurance companies started denying fire claims by blaming the earthquake, and the public outrage was enormous. In 1909, California enacted the standard fire insurance policy, specifically to prevent insurance companies from denying losses caused by fire. That policy is now codified in an Insurance Code Section 2071. Now, the standard form requires coverage for, quote, all loss by fire. And courts have recognized for over 130 years that this includes injury done by combustion, heat, smoke, and the expansive effect of fire. This is not new law. This is settled law that insurance companies are now trying to relitigate. Section 2071 establishes the mandate, coverage for all loss by fire. And then Section 2070 establishes the enforcement mechanism. All risk policies that offer more coverage than just fire may deviate from the standard form. However, with respect to the peril of fire, they must offer coverage that is substantially equivalent or more favorable to the insured. So everybody probably has an all-risk policy. Maybe some people have fire-only policies from California Fair Plan, possibly. But most typical homeowners policy, State Farm, Farmers, AAA, Mercury, is what's written on an all-risk form, which means they cover more than just the peril of fire. And so when they're talking about perils other than fire, they can use language that's different than all loss by. But when we're talking about a loss that is the result and caused by fire, whatever the language in the policy is, it has to be interpreted to be the substantial equivalent. It cannot offer anything less than 2071. If the policy language is less favorable than all loss by fire, if it provides less coverage, that language is invalid. The California Supreme Court has confirmed this. The standard form provisions for a fire set the floor for fire coverage. Insurance companies cannot go below that floor by adding restrictive definitions like permanent physical damage or requiring physical alterations in order to trigger coverage. It's not optional. Yet the insurance industry ignores 2071. I guarantee almost every one of you that has received a letter from your insurance company never cites Insurance Code 2071. They probably all cite their policy language, which says you have to be able to establish a loss caused by direct physical loss or damage. And then they like to interpret the term direct physical to mean a physical alteration or something like that. And when they take positions like that, they are taking positions inconsistent with Insurance Code 2071 and inconsistent with California law. So I've talked about this. 2071 is broad, all loss by fire. It's the statutory mandate. And as I just sort of talked about, direct physical loss or damage is narrower. It adds requirements like direct or physical. It's subject to the Section 2070 equivalency test. So just keep that in mind. If any of you people are dealing with those issues, that's something you can ask questions about at the end, and I'd be happy to answer them. And here's something to think about, okay? The Department of Insurance has already spoken on this subject repeatedly and clearly. In 2022, They, meaning the Department of Insurance, did a market conduct examination of the California FAIR Plan. And they cited FAIR Plan for numerous violations and found that contrary to Insurance Code 2070 and 2071, FAIR Plan failed to issue a fire policy when viewed in its entirety that was substantially equivalent to or more favorable to the policyholder than that contained in the California Standard Form Fire Policy. And that means FAIR Plan failed to provide coverage for all loss by fire as set forth in Insurance Code 2071. In January 2021, the Department of Insurance's General Counsel wrote to FAIR Plan and said, quote, any attempt by FAIR Plan to reduce or limit coverage for smoke damage based on its definition of direct physical damage to require permanent physical changes to covered property is contrary to the law. That's the Department of Insurance's position. Section 2071 mandates all loss by fire. Yet, insurance companies today are trying to systematically limit smoke damage claims. And the department has backed up its interpretation with recent enforcement. Okay, on March 7th, Commissioner Lara issued Bulletin 2025-7, specifying that all insurers are required to, quote, fully and fairly investigate smoke damage claims. The bulletin makes clear that insurance companies cannot summarily deny claims without appropriate investigation. And if testing is warranted, and with toxic contamination from urban wildfires, it almost certainly is, the insurance company should contract and pay for these services. Yet I know many of you who are here have had to pay out of pocket to have testing done. I know many of you who are here originally requested your insurance companies to test and were told no. And we're told we're going to send out a ServPro or a Service Master or some other company to evaluate what the remediation or restoration should be. Okay, that would be like going to the doctor because you have back pain and your doctor saying they want to do surgery without any imaging whatsoever. That would be medical malpractice. And it's malpractice in the insurance context to try to evaluate a scope of repair without the appropriate testing when the nature of the loss is smoke contamination. On July 31st of this year, the Department of Insurance filed an order to show cause against California FAIR Plan, citing a continuing pattern of denying smoke damage claims based on their arbitrary permanent physical damage requirement. Commissioner Ricardo Lara stated, quote, we will not tolerate insurance companies breaking the law and denying Californians the coverage they deserve. Yet insurance companies, FAIR Plan and others, continue to ignore Insurance Code 2071 and take contrary positions to minimize smoke damage and to minimize the rights that you have under Insurance Code 2071. Now, in June 2025, a California court ruled on exactly this issue in Aleph versus California FAIR Plan. The court held that FAIR Plan's attempt to restrict coverage for losses from fire, requiring in their policy that there be permanent physical changes that are visible to the naked eye and smellable to the unaided nose. And in their policy, they literally said that they would refuse to consider scientific testing evidence. The court found that each one of those was unlawful because it limits coverage to be less favorable than the all loss by fire standard as required under Insurance Code sections 2070 and 2071. Insurers are taking ludicrous positions. They are taking self-serving positions. But those positions, when they are at odds with Insurance Code 2070 and 2071, are unenforceable and legally untenable. Sidestepping Insurance Code 2071 altogether, insurance companies are trying to cherry-pick language from the California Supreme Court's COVID-19 decision in a case called Another Planet to try to support limiting coverage for smoke damage. I've personally seen denial letters from insurance companies quoting the physical alteration and easily cleanable language from the COVID-19 decision to support denying coverage to properly restore and address smoke contamination. They argue homes with smoke contamination can be easily cleaned and therefore do not qualify for coverage. These insurance companies outright acknowledge test results showing contamination, but then deny the claims anyway, or refuse to pay for the true extent and scope of restoration that is needed. In reality, the Supreme Court's decision in Another Planet has absolutely no relevance to fire claims because it did not address the statutory standard as spelled out in Insurance Code 2071. Regardless, okay, a careful read of Another Planet doesn't even support the position that insurance companies are taking, because even if it were applicable to fire and smoke claims, a careful read shows that it actually supports coverage. This is because the Supreme Court in the COVID context identified 3 independent triggers for coverage under a policy that requires direct physical loss. So when we're not talking about a fire loss and we're talking about some other type of loss, the policy that says in order to satisfy coverage, you have to demonstrate direct physical loss or damage. Okay, well, in a fire loss, we're not worried about that. We're talking about all loss by fire. But regardless, even if direct physical loss or damage were the standard, okay, if it were the standard, what we would be looking at is, first, the Supreme Court acknowledged that physical alteration does not need to be visible to the naked eye, and it can include alterations at the microscopic level. Well, that's what testing shows. Second, the Supreme Court acknowledged that functional impairment of property can trigger coverage. When a property is, quote, rendered effectively unusable or uninhabitable, including from contamination or noxious odors, well, that's what we have in these smoke contamination claims. Your properties are deemed uninhabitable. You can't use them. You can't live in them. That makes it functionally impaired. And third, the court said when active remediation is necessary to restore the property, coverage is triggered. Well, we have that too. When there's saturation or ingraining or infiltration of a substance requiring active remediation, coverage is triggered. So even under the non-fire standard that the Supreme Court announced in the COVID context, there wouldn't be a coverage problem. The insurance industry focuses on one word or one part of the Supreme Court decision, the term physical alteration, and they deem that to mean something different than what the court actually spoke about. They try to use the word physical alteration and say, oh, well, the smoke claims aren't altering your property, right? Not in the way that a flame does. It's not discoloring it. It's not changing it in some visible way, so there's no coverage. They're just wrong. And let me be clear about what Another Planet is and what it's not. Okay, Another Planet is not an interpretation of Insurance Code 2071. Another Planet is a COVID-19 case about the evanescent presence of a virus that dissipates naturally and can be removed easily by routine cleaning, such as Clorox wipes and household sprays. It's not a fire coverage case. It's not a holding that smoke damage isn't covered or can be limited. The critical distinction is that COVID-19 particles are evanescent. They dissipate on their own, smoke persistent, it's physical, it makes homes uninhabitable, and does not dissipate without active restoration. The easily cleanable standard from COVID-19 cases does not apply to toxic smoke contamination that requires professional hazmat restoration. And here's something that the insurance industry doesn't want you to know. During oral argument in Another Planet, the California Supreme Court expressed concerns about the potential that a holding that the COVID-19 cases doesn't always cause physical loss or damage might be used to narrow existing coverages, including for smoke damage. Okay, Supreme Court Justice Liu asked the insurance company's lawyer to distinguish COVID-19 from other substances that courts have routinely found to cause physical damage. And in response, the lawyer conceded that smoke damage is among the categories that indisputably cause compensable loss. Later during the oral argument, Chief Justice Guerrero specifically expressed concern about the application of a holding in favor of the insurance company, asking whether cases holding that noxious gases, fumes, and wildfire smoke are physical damage would remain intact. And the insurance company's lawyer agreed that there would be no change in the long-settled law. The insurance industry cannot now pretend that smoke damage isn't covered. Their own lawyers conceded this point before the highest court in our state. Now, some of you might have read or heard about a case called Garibian versus Wawanesa. This was a case that came out in February of last year, and the insurance industry has been citing it since to justify denying or minimizing smoke damage claims. And let me give you a quick run through about why their reliance is entirely misplaced. Okay, so Garibian is a failure of proof case. The plaintiffs in that case presented no expert evidence of contamination. Their own hygienist that they hired in the litigation that they didn't use before said that the ash didn't actually cause damage to their home. They submitted no testing and had no scientific evidence to demonstrate how the purported smoke damage affected their property at all. Well, when you present no evidence, courts find no coverage. That's not really surprising. But here's the critical point. The court never addressed the elephant in the room. Insurance Code 2071 was not cited by either party. The case is one that simply is limited to its facts. It is not a broad proposition on the nature of smoke contamination under California law. And the Department of Insurance actually agrees. The Department of Insurance issued a bulletin in March of 2025 explicitly stating that Garibian does, quote, not support the position that smoke damage is never covered as a matter of law, and it is limited to the facts presented in the case. Now, the contrast between Garibian and cases with actual evidence is stark. So in Garibian, as I pointed out, there was no contamination evidence, no hygienist testing, and the plaintiff's own expert said no damage. So it wasn't surprising that the insurance company prevailed. But when we contrast that with cases where we have presented robust expert evidence, we see results that are on the flip. So I represented two families in the last year where we went forward in court against Allstate Insurance Company. And in both cases, we produced robust scientific testing. So in Nolte versus Allstate, we had a certified industrial hygienist reporting and documenting severe damage. They did significant chemical testing. They demonstrated thermal damage, non-thermal damage, and contamination of all different types. The insurance company tried to argue using Garibian, saying, oh, it's not covered. They tried to cite to the California Supreme Court decision in Another Planet. Oh, it's all easily cleanable. The judge said, no, your motion is denied. The plaintiffs get to go forward to a trial to prove their case. Same result in Hamilton versus Allstate. We documented the toxic contamination that many of you are seeing in the reports that you've received. VOCs, cyanide, formaldehyde, heavy metals. And when presented with this evidence, and the insurance company making the same types of arguments, the judge was not in the least persuaded, denied their motion. So to just sort of back up, the law is not complicated in this area. When policyholders and homeowners such as yourself present evidence of contamination to your homes as a result of fire, you're entitled to coverage. The Garibian case doesn't change that. The insurance industry's interpretation of Another Planet doesn't change that at all. And federal courts are weighing in as well. They're explicitly distinguishing COVID-19 cases from smoke contamination. So in January of last year, I had a case called Bottega LLC versus National Surety. And in that case, National Surety tried to make the very argument that smoke didn't cause physical damage, and therefore our client's restaurant was not entitled to business interruption losses. And the court disagreed, finding that whereas a virus is more like dust and debris that can be removed through cleaning, smoke is more like asbestos and gases that physically affect and functionally impair property. And the Eighth Circuit Court of Appeal recently found similarly in a case called Max's, M-A-X-U-S, Metropolitan versus Travelers. And in that case, they held that contamination requiring remediation constitutes a covered loss and that microscopic soot particles constitute covered damage. At trial, the insurance company's position was straightforward. They argued that the smoke never traveled to the buildings. And they brought forth the same argument that I'm sure many of you are facing. They tried to argue that all of the contamination that was found was background, neighborhood dust, unrelated to the fire. And even if some microscopic contamination was present, they argued that the microscopic particles did not constitute direct physical loss or damage under the policy. The property owners presented evidence that the smoke contamination was throughout the buildings, including in the wall cavities, and presented an estimate to fully and thoroughly restore all of the smoke contamination. And the jury returned a substantial verdict to the tune of $27.3 million in damages. Now, this was a commercial property with multiple buildings, so it was a much larger scenario than a simple home. But it showed that when they presented their evidence, the jury returned a substantial verdict. And on appeal, Travelers doubled down, arguing that microscopic contamination cannot be physical damage as a matter of law. And the Court of Appeal in the Eighth Circuit rejected it, finding that smoke contamination physically affects property. It's material, it's perceptible, it's tangible, and it functionally affects how a property can be used. The court there, just like the court in my case, compared it to asbestos, not COVID. And the court found that smoke contamination is permanent in nature and requires proper and thorough intervention. So now let's summarize before we move on. Okay, first, Insurance Code Section 2071 mandates coverage for all loss by fire. Second, the DOI enforcement actions confirm that smoke damage must be covered. Third, courts are rejecting insurance company attempts to narrow coverage. Fourth, another planet is not a fire case, but nonetheless supports coverage when contamination requires active remediation. Fifth, the Caribbean case that many of you have probably seen cited in letters is limited to its facts, and all it stands for is the proposition that no evidence means no coverage. That's it. The question is not whether the law requires coverage for smoke damage. The law clearly does. The question is whether insurance companies will comply. We now turn to a fundamental question that insurance companies refuse to answer. Who is certifying that your homes are safe? Not cleaned, not serviced, safe for a child to crawl on the floor, safe for a cancer survivor to breathe the air. Now, your homeowner's policies require insurance companies to make that safety determination. The dwelling coverage requires the insurance company to restore your property to, quote, pre-loss condition. Pre-loss condition means the home that you had before the fire. No smoke contamination, no toxic residues, no health hazards. Similarly, your ALE coverage, your additional living expense coverage, continues while your home is uninhabitable due to a covered peril. Uninhabitable means unsafe to occupy. To terminate your additional living expense, the insurance company must determine, is the home habitable? And to close your dwelling claim, the insurance company must determine, has the home been restored to its pre-loss condition, or is the methodology that is being called for to do the restoration capable of bringing it back to its pre-loss condition? Both questions require answering one fundamental question: is the home safe? This isn't an additional requirement that I'm seeking to impose. It flows directly from what California law and the policy directly require. The dwelling claim requires proving contamination has been eliminated to show that the home is restored. The ALE claim requires proving the home is safe to show it's habitable. And if the insurance company cannot prove that the home is safe, it cannot prove habitability and therefore cannot terminate ALE. If the insurance company cannot verify that the contamination has been eliminated, it cannot prove restoration to pre-loss condition and therefore cannot close the dwelling claim. The safety evaluation is inherent in what the policy requires. It's not an extra step. It's the logical necessity of the coverage terms. And it's the logical necessity of California's all loss by fire state. Now, here's what insurance companies are actually doing versus what the law requires. Insurers are terminating ALE, telling families to return home, claiming that their remediation method must be used, and closing dwelling claims. But they're not having anyone qualified determine safety. They are not having anyone certify habitability. And they are not having anyone verify that pre-loss condition has been restored. The Eaton Fire Residents United data that I talked about earlier, it reflects 43 out of the 45 post-remediation tests that they had. They all underwent insurance-backed remediation, and they still contained contamination. The New York Times identified children with elevated heavy metals in their bodies. We have families being told that they have to move back to toxic environments, with insurance companies closing the claims. Now, I got to see one of the Department of Insurance Smoke Remediation Claims Task Force members give a presentation. Okay, his name's Patrick Moffitt. He's an industrial hygienist by trade. And during his presentation, he said, as a hygienist, he doesn't feel comfortable speaking to safety. So that begs the question, if the hygienist cannot certify safety, who does? Well, right now, the answer is no one. No one on the insurance side is doing that, despite the fact that the policy requires it. Every other regulatory context involving hazardous contamination requires health professional involvement before declaring sites safe. Superfund sites require risk assessment by toxicologists and health-based protective standards. Lead abatement under HUD and EPA regulations require clearance testing before reoccupancy. Asbestos removal under OSHA and EPA require air monitoring and no reoccupancy until clearance. Workplace exposures under OSHA have permissible exposure limits based on toxicological data with medical surveillance. In October 2024, the EPA strengthened their lead standards, recognizing, quote, there is no level of lead in blood that has been found to be safe for children. So the question is, why should California families, including children, receive less protection in their homes than workers in renovated buildings or communities near Superfund sites? The standard that we're proposing, the standard that Eaton Fire Residents United is pushing through, trying to get through the legislature, flows directly from California law and the insurance policy provisions. A complete investigation must include pre-restoration testing by a qualified, independent industrial hygienist. I say independent because I'm speaking to not somebody that has ties to the insurance company when the insurance company is writing their checks and they have an incentive to write a report in a certain way. Okay? The investigation must include a health risk evaluation when contamination is identified. And there has to be a consideration of vulnerable occupants like children like the elderly and immunocompromised. Post-restoration testing has to be done to confirm that the hazard has been eliminated, and there should be a written safety determination before additional living expenses are terminated or the claim is closed. If the insurance company cannot prove that the home is safe, it cannot terminate additional living expenses. And if the insurance company can't prove contamination is eliminated, it cannot close the dwelling claim. No safety certification equals, in my mind, no claim closure. No one would accept the asbestos was removed without clearance testing. No one would accept the lead was abated without verification. Why do we accept the smoke was cleaned without anyone certifying safety? We now turn to the documented claim handling violations, the systematic pattern of conduct that California courts are finding constitutes bad faith. So insurance companies have a legal duty to investigate, not just the facts that support denial, but also the facts that support coverage. Your insurance companies must, by law, conduct a thorough, fair, and objective investigation. And the law is clear. An insurance company cannot just focus on the facts that justify denial. They must diligently search for evidence that supports coverage. And here's another critical point. Insurance companies are charged with constructive notice of the facts they would have discovered if they had properly investigated. And if an insurance company fails to investigate, they cannot later claim it didn't know about the contamination it would have found had it done a proper investigation. The law charges insurance companies with knowledge of what a proper investigation would have revealed. Now, let me be specific about what the duty to investigate requires, because I know many of you have been running around in circles trying to figure out, why isn't my insurance company doing anything with the information I've provided? Why aren't they independently searching for information to evaluate what the proper scope of repair is at my home? Why aren't they searching to tell me whether my home is safe? So the standard jury instruction that juries are told in California states that insurance companies must give at least as much consideration to your interests as they give their own. There's a Supreme Court case called Egan, and it requires insurance companies to, quote, diligently search for and consider evidence that supports coverage. Now, critically important for all of you, because I'm sure you're dealing with situations like this. If an insurance company seeks only the evidence that would defeat the claim, that means it's holding its interests above yours, and that is bad faith. A one-sided investigation seeking only evidence that defeats your claim is per se insufficient. Period, hard stop. The first-party claim process is not supposed to be adversarial. The insurance company owes you duties to assist you with the claim, not to act as your adversary. Yet, one-sided investigations are what we are seeing. Smoke contamination victims asked their insurance companies to hire experts to test their homes, and many were originally told no. Then, I'm sure many of you, after being told no, went out of pocket and retained your own experts. Then, when your own experts obtained data after testing and you presented that information to your insurance company, the insurance company, rather than accepting the evidence that you went out and got and that you went out and paid for, essentially doing their job for them, they didn't accept that. That's when they went out and hired their rebuttal experts, somebody to rebut the information and evidence you presented, somebody to minimize the evidence and information you presented, somebody to say that your scope or the extent of contamination is wrong and that something less is true. Then the insurance company finally gets around to doing their own testing, often many, many months later, often performed by the same expert who was already used by the insurance company to contest the smoke contamination evidence that you presented. And not surprisingly, these insurance company experts test for less, contaminants, test in less places, and then claim that the property can be easily cleaned for far less and with a much smaller scope than what your experts have called for. The insurance company then demands that you quickly utilize their methodology or that they're going to start or be prepared to cut off your additional living expense. And then you're forced with the situation of either moving back into a contaminated home or somehow find the resources elsewhere. This is not how insurance is supposed to work. You paid premiums for the promise that your insurance company would help you through these difficult times, not that they would treat you as an adversary. And this pattern, it's not new. There was a case that came out in 2015 called Investigative. It was a wildfire from the 2015 Valley Fire. And that case documented the exact same tactics. In Investigative, the first insurance adjuster that State Farm sent out acknowledged that the damage was related to smoke and soot. The second unlicensed adjuster claimed they couldn't find any smoke damage. State Farm hired an expert called FACS. Now, FACS did surface sampling only. They didn't test in the wall cavities, they didn't test in the HVAC, and they did no air testing whatsoever. State Farm's expert blamed background for the contamination. They blamed candles, they blamed the nearby barbecue, and they blamed the homeowner's fireplace for the evidence of smoke damage that they found, rather than attributing it to the wildfire. State Farm took absolutely no steps to verify the reasonableness or accuracy of its experts' analysis. And the result was that the Court of Appeal found that, quote, a jury could conclude that FACS, that was State Farm's expert, was not retained to offer an unbiased report, but instead was retained to rubber stamp the decision to pay no additional benefits. That was 2015, and nothing has changed. The San Francisco Chronicle investigation documented the pattern of how insurance company experts operate. Insurance company experts attribute cyanide in hallways to gas fireplaces that don't burn wood and vent outdoors. They attributed lead at 1,000 times the federal limit to background contamination. Just like in the Investigative case, they blame candles and barbecue pits for heavy metals. And the insurance company's internal guidelines are telling adjusters not to use words that will trigger coverage. State Farm adjusters are repeatedly told to avoid communicating key facts in writing. And there was even one condescending expert report that calculated that a child would need to eat 100 kilograms of baseboard to die from lead exposure, as if the only concern is immediate death, not neurological damage to developing brains. Experts selected to advocate for the insurance company, not to evaluate evidence objectively or fairly. Now, why do insurance companies regularly retain these biased experts? Well, they do so because they believe that it will help insulate them from bad faith liability, from extra contractual liability. Well, not so fast. A biased investigation defeats what is known as the genuine dispute defense. So what insurance companies try to do is they try to say, I've hired an expert, and my expert has told me that there's no more damage, or my expert has told me that this minimal methodology will work, and therefore I'm allowed to rely on my expert. And so I don't have to agree with what your hygienist is saying or with what your expert is saying. Well, the courts have looked at that argument before, and this is what they've said. A biased investigation defeats that defense. Okay, the Ninth Circuit Court of Appeals in a case called Hangeter said that a jury's finding that the insurance company's investigation was biased can preclude a finding of the genuine dispute, even if the insurance company advances expert opinions. So an expert opinion in the abstract doesn't create a reasonable dispute to avoid bad faith liability. Hiring experts does not create automatic immunity. As the court in the case called Chateau Chambray said, quote, an insurance company cannot insulate itself from bad faith by hiring an expert to manufacture a genuine dispute. And the Wilson case makes it even clearer. The genuine dispute defense, quote, does not relieve an insurance company from its obligation to thoroughly and fairly investigate. An insurance company cannot hire an expert it knows will deliver a favorable opinion, accept that opinion without scrutiny, reject your contrary evidence, and then claim that the dispute is genuine or reasonable. That is not a reasonable dispute. That is manufactured insulation and the definition of bad faith. And that, unfortunately, is what we are seeing. And the Department of Insurance is seeing what we are seeing. People are crying out for help. The July 31st, 2025 order to show cause against California Fair Plan cited hundreds of violations. The department reviewed hundreds of complaints. People complained of noxious fumes so strong they couldn't stay with an N95 mask, and yet they were told to mop broom and use a vacuum, and their claim was denied. People with respiratory symptoms claimed that they entered their home and that their entire home was impacted by smoke and soot. The insurance company said, your house is habitable. ALE denied. Another insured said that there was soot throughout the interior and that there was a heavy smell permeating their property. The insurance company denied the claim because there was, quote, no physical damage. And it's not just California Fair Plan. California's largest admitted insurance company, State Farm, is also under a market conduct examination for the same practices. And the county of Los Angeles the attorney for the county is investigating State Farm just the same. They are seeing the same pattern that we are. Patterns of unreasonable conduct with almost every single insurance company handling smoke contamination claims. Now, one quick thing I just want to touch on is that some of you might have gone to your doctors, and some of you might be immunocompromised, be survivors of things like cancer, and you might have asthma issues and the like. And I encourage you, go to your doctors, give your doctors the contamination testing that you have, because presenting your insurance company with evidence from a health and safety professional is going to be helpful to your case in the big picture. Now, in the case of the Pineda family that the New York Times documented, we saw something quite insidious. It shows the human cost of these insurance company practices. Now, Mrs. Pineda was a documented stage 3B cancer survivor and was immunocompromised. And according to the New York Times, her oncologist wrote to Farmers Insurance with a medical recommendation to replace all of the soft goods due to the carcinogen exposure risk. The insurance company adjuster's response was that the oncologist's recommendation was dismissed because the doctor didn't personally perform the testing. Let that sink in. Medical expertise from an oncologist treating a cancer patient dismissed because the doctor didn't personally perform the testing. But interestingly, the insurance company didn't do any testing either. Mrs. Pineda, according to the New York Times, described it as being in a dream where you're screaming at the top of your lungs and nothing comes out. And I know her experience is similar to many of yours, feeling like you're going around in circles and you can't believe what you are dealing with, how you are dealing with an insurance company that is refusing to take the situation seriously. But courts are recognizing the pattern. In Nolte versus Allstate, Allstate ignored our client's hygienist testing evidence. They relied on biased experts, and they argued that the property could be easily cleaned and that nothing more than the cost for basic cleaning was owed. Allstate tried to hide behind its biased experts to argue that it could not be held liable for bad faith or for punitive damages. And the court held otherwise. The court denied their motion. In Hamilton versus Allstate, which was in July of 2025, we convinced the court of the same result. In both cases, the court found reasonable juries could find that the insurance company's conduct was unreasonable and subjected it to bad faith and punitive damages. In denying those motions and permitting these issues to go to a jury, the Hamilton court explained that a reasonable jury could find that by, quote, failing to thoroughly investigate the claim and disregarding the hygienist report submitted by the policyholder, the insurance company engaged in despicable conduct carried on with a willful and conscious disregard of the rights of plaintiffs. That's the key. If they deny or ignore the reports that you are submitting and solely focus on the reports that they have paid for that are biased, and when you call out discrepancies and you call out problems in their report, they just bury their heads in the sand, that is the type of evidence that courts will agree is unreasonable and should go to a jury on bad faith. I now briefly want to try to talk about what the insurance industry is doing in response to these claims. In January of this year, the insurance lobby provided a presentation to the Department of Insurance Task Force to try to put their spin on what smoke contamination claims are and what they should be entitled to. Their presentation used a four-part strategy: misdirection, legal reframing, weaponizing uncertainty, and economic threats. So before I respond to the specific claims, let's understand what the industry is doing. First, they're trying to reframe the problem. You all, the families, become alarmists. Testing becomes a rabbit hole. The crisis becomes about fraud and money chasers rather than contaminated homes. Second, they try to shift the legal standard away from California's all loss by fire standard to something narrower, direct physical loss, framed from the COVID-19 litigation. Third, they try to weaponize uncertainty, arguing that because no perfect standard exists, because there is no current standard issued by the government for cyanide or for beryllium or for other contaminants that are found, that the insurance companies can minimize restoration or testing and deny claims. And fourth, and this is different from the others, they're applying economic pressure. They are lobbying about market collapse, risk pooling failure, premium spirals. And the message that the insurance industry provided to the Department of Insurance is clear. What they argued was, if you enforce the law as written, we will make California uninsurable, and then we will blame you. 3 of those are misdirection, and 1 is a threat. And none provide a reason to abandon consumer protection. And that is why we're here to provide protection for all of you. Now, fraud exists in every single catastrophe, but you don't fix fraud by treating every family as a suspect. The Eaton Fire Residents United objective data shows that homes are still contaminated after insurance-approved cleaning. I've seen hundreds of families produce and provide objective data reflecting their homes are contaminated. These families are not committing fraud, and they are not smoke chasers. They are seeking simply to go back to their homes in a safe way. All they want is to be able to go home. You all pay premium in exchange for the promise that your insurance company will be there when disaster strikes. Insurers are instead treating those money-paying insurance customers as fraudsters, treating every smoke contamination claim as an adversarial process, treating every policyholder as a fraud suspect, refusing to acknowledge evidence that you present out of fears that it is driven by smoke chasers, out of fears that it is not objective, reasonable, or fair. The insurance company is not considering your interests, and they are failing to consider what the law requires of them in this context. The industry says mere detection doesn't equal damage. And they say testing for substances without governmental standards is an unnecessary rabbit hole to nowhere. Well, let's think carefully about what they're actually arguing. Beryllium is a Group 1 carcinogen, the highest classification. Dr. David Michaels, the longest-serving OSHA administrator in history, says there is no safe level of beryllium exposure. Chronic beryllium disease is debilitating and often fatal, but there's no residential restoration standard for beryllium. So does that mean we don't test for it? Hydrogen cyanide is generated when plastics and foams burn. It embeds in porous materials like drywall, and it forms stable salts in ash. But again, there's no residential restoration standard. Does that mean we don't test for it? The insurance industry's argument is because there's no governmental standard, testing is pointless. But that logic doesn't make sense. The law requires restoration to pre-loss condition, a safe, habitable home. To fulfill that obligation, the insurer needs to demonstrate that the home is safe. There's a logical sequence to do that. First, you have to actually test to determine what's there. Then, a qualified professional makes a health and safety determination. Then, you restore the property based on what was found. Then, you verify with post-clearance testing that the home is safe to occupy. Testing, determination, restoration, verification. Now, look at their arguments through that lens. Mere detection doesn't constitute damage, but detection is how you identify what needs to be restored. If beryllium is in the HVAC and it came from the fire, that's not mere detection. That's identification of damage that is a health and safety concern. The contamination is the damage. Detection is just how you find it. It's how a health and safety professional can weigh in. Comprehensive testing leads to rabbit holes. A rabbit hole to where? To finding contamination. That's only a problem if your goal is not to find it. If your goal is to restore a property, to make it safe, to make it habitable, comprehensive testing tells you the scope of work. It's not a rabbit hole. It's the job. Calling it a rabbit hole reveals their motive. They don't want to test because they don't want to find. They don't want to have to properly restore. They don't want a qualified professional making the safety call because that professional might say that the home is not safe. So instead, they test for the bare minimum, they approve only surface cleaning, and declare it ready for occupancy. No comprehensive testing, no health and safety sign-off, no post-clearance verification. The Van Ness family is what happens. Farmers approved cleaning. The cleaning was done, and the family moved back in, and that's when they found all of the additional damage when independent testing was done. That's not a failure of science. It's a process designed to minimize what's there so that the insurance company can minimize what they pay. This is a category error disguised as common sense. No one is asking insurance companies to cover asthma or cancer treatment. We're asking them to restore property to pre-loss, safe, habitable conditions. A home is not safe if it's filled with fire contamination. And to terminate additional living expense, they have to prove that the home is habitable. Habitable means safe to occupy. That's not health insurance. That's what your property insurance policy requires. They're trying to escape a contractual obligation by mislabeling it. They say no science-based standards exist for smoke restoration. They say we need industry consensus. They say uncertainty justifies their approach. But let's be clear about what's happening. California already has a standard. It's been the law for over a century. Insurance Code 2071. Every fire policy in the state must cover all loss by fire. All loss. Not visible loss, not the loss the industry agrees to recognize, and not loss for which there's a government standard. all loss. That includes smoke, it includes soot, and it includes every contaminant that the fire deposited in your home. Beryllium, cyanide, lead, heavy metals, and SVOCs. And if it came from the fire, it's a loss from that fire. That's what the law says. So when the industry tells you that no standard exists, understand what they're really saying. They're not trying to fill a gap. They're trying to replace a broad legal standard with a narrow, self-serving, technical standard that they themselves write. We saw the playbook. I walked you through that IICRC technical guide. Conclusions first, authors with industry ties, a closed loop of self-citation. That's not filling a gap in science. That's manufacturing a standard designed to minimize what counts as a loss. The legal standard says all loss by fire. Their manufactured standard says only what we choose to test for, only what we can see or smell, only what exceeds thresholds we haven't yet agreed on. That's not consensus. That's narrowing. And here's where their logic breaks down entirely. They argue uncertainty. We don't have perfect thresholds. We don't have complete science. And then they use that uncertainty to justify doing less. That's backwards. When there's uncertainty about what's safe for a child to breathe, that's not a reason to declare a home safe. That's a reason for precaution. We understand this everywhere else. Lead paint, we don't wait for a child to show symptoms. We test, we restore, we verify. Same with asbestos, same with Superfund sites. Uncertainty triggers protection, not abandonment. But here the industry says, we don't know exactly how much beryllium is dangerous, so let's not test for it. We don't have residential standards for cyanide, so finding it is meaningless. But that's not science, that's strategy. The standard already exists. Now, the economic argument is different from all of the others. The industry warns about market stability, risk pooling premium increases, fair plan collapse, and let's call it what it is. It's not a legal argument, it's a threat. They're saying, if you make us pay for what the law requires, we'll destabilize the market and you'll be responsible for the consequences. Well, Insurance Code 2071 doesn't have an affordability exception. The cost of a covered loss doesn't change whether it's covered. If premiums need to rise to cover actual fire losses, that's a rate question for the Department of Insurance. If the market needs reform, well, then that's a legislative question. But what it's not, and what it can never be, is a justification for denying valid claims or sending families back into contaminated homes. Here's what the insurance industry didn't present in their presentation: accountability. They want to terminate ALE and close claims. Fine. Then answer the question. This is what they need to answer. Who is certifying that your homes are safe? Not cleaned, not serviced, safe. Safe for the elderly, safe for the immunocompromised, safe for children, safe for a cancer survivor. The hygienists say they don't feel comfortable speaking to safety. The insurance companies say property insurance isn't health insurance. The adjusters close the file and tell families to move back in. But no one from the insurance industry side will put their name on a document that says the home is safe to occupy. The policy requires establishing habitability to terminate ALE. It requires proving restoration to close the claim. Both require answering the fundamental question, is the home safe? And if no one qualified will certify that, the claim isn't finished. And again, it's not a new standard. That's what the law and the policy require. Now, you've seen the problem. Insurers making safety decisions that aren't qualified to make it. They're telling the families their homes are safe when the science says otherwise. Recently, 2 pieces of legislation are moving through Sacramento that are trying to fix this. Both sound good on paper, and neither is there yet. I want to briefly go through what you need to understand so you can advocate effectively. And I say that critically. You all need to take matters into your own hands and reach out to your local assembly people. This affects you and it will affect future Californians on this issue. We need to speak up directly to our legislature to make sure that things are handled correctly. So let's break both of these bills down one at a time. Okay, Assembly Bill 1642. This is called the Wildfire Environmental Safety and Testing Act, and this is authored by Assembly Member John Harabedian. Harabedian isn't writing this bill from the abstract. He's representing communities directly impacted by the fires. He's been vocal about insurance company misconduct in his district, and he's actually one of the people that pushed for the State Farm market conduct investigation. His bill asks a fundamental question that nobody in the current system is answering. Who's qualified to decide whether your home is safe to live in? So let's talk about what it does, why it matters, what's right about it, and what we need to watch out for. The core question that this bill asks is simple but powerful. Who is actually qualified to decide whether your home is safe to live in after a wildfire? Well, right now, as we've talked about, the answer is nobody with the right credentials. What AB 1642 says is let's put this in the hands of the Department of Toxic Substances and Control. This is an agency that handles Superfund sites and toxic cleanups. They are familiar with science, and critically, they don't answer to the insurance industry or its lobby. The bill directs the Department of Toxic Substances and Control to develop science-based testing and restoration standards to establish clear criteria for when a home is safe for reoccupancy, and to do it all through its own regulatory process, independent of the Department of Insurance. And in my mind, that's really important. Now, I don't have time to get into the Department of Insurance task force. I'll touch on it briefly when I get to the next bill. But the Department of Insurance Smoke Remediation and Claim Task Force is highly compromised. It is made up of people who have industry ties, made up of people who are probably involved in many of your claims to deny your claims. And so to have a bill tied in any way to those people raises significant concerns. The fact that this bill is independent of the Department of Insurance is a good thing. Now, let me walk you through what I call the safety gap. This is the structural problem AB 1642 is designed to fix. So you start with the industrial hygienist. You hire them, or your insurer does. They run tests, they detect contamination. But here's the thing. By professional convention, industrial hygienists don't typically render opinions on whether a home is safe to live in. They report the data. They don't typically make reoccupancy decisions. Now, on the other side, your insurance adjuster has no training in toxicology, no background in environmental health, and they're the ones who are effectively deciding whether your home is safe. They're the ones terminating your ALE benefits, but they have zero qualifications to make that determination. And so nobody in the current system is actually qualified to tell you your home is safe to bring your children home. Most hygienists won't say it. Now, some have different types of health and safety background and might be willing to, but the majority of them won't. The adjusters certainly have no qualifications to address it, and there's nobody else in the picture. What AB 1642 does is fills that gap. It says qualified public health professionals working under DTSC have to make that call. Not adjusters, not the insurance department task force, scientists. This is a good thing. It should be independent and objective, evaluating what the appropriate scope of testing and restoration is should not be tied to industry lobbying efforts. Now, let me tell you what's right about this bill, and there's a lot to like. First, as I said, it's the right agency. DTSC, they handle the Superfund sites, toxic cleanups, and hazardous waste. That's literally their job. Okay, they work with toxicologists and environmental scientists, and there's a regulatory framework for exactly, in my mind, this type of contamination. And secondly, it's the right framework. At least I think so. If you have lead paint in your home, HUD requires clearance testing before your family can move back. If you're removing asbestos, OSHA requires air monitoring. Your homes are exposed to burning plastics, heavy metals, and carcinogens. Your children deserve at least the same level of protection that the law provides in other contexts. And third, I think it's the right author. Remediation represents part of the community that was affected. He's not writing this for the abstract. He's seen what's happening to his constituents, and he's been vocal about insurance company practices. And as I said, it's independent of the Department of Insurance. As I understand it, DTSC would develop these standards through its own process, not through a body that, as we've documented and that I briefly touched on, has conflicted interests. Now, let me be honest about the risks, because I don't think blind enthusiasm helps anyone. First, the industry opposition is coming. The insurance lobby will argue that this will add costs, delay claims, and duplicate the work that the task force has already undertaken. And you need to be ready to counter every one of those arguments. The cost of comprehensive restoration is not an extra cost. It's the cost of fulfilling the insurance contract. The delay argument is ironic, coming from insurance companies who are already delaying your claims and duplicating the work of the task force. The task force has documented conflicts of interest. Independent oversight is exactly what's needed. Secondly, DTSC capacity. This is a real concern. Okay, DTSC is a real agency with resource constraints. Emergency regulations take time, even fast track ones, and families need protection now. So the key question is, what are the interim protections while the DTSC develops permanent standards? Third is political viability. The insurance lobby is one of the most powerful in Sacramento. This bill needs vocal constituent support to survive. Your voices, your stories, your data. That's what gives it legs in the committees. Now let's look at the second bill that came out about a week or maybe a week and a half ago, AB 1795. I believe it's titled the Smoke Damage Recovery Act. This one is authored by Assemblymember Mike Gibson, and it has the support of Insurance Commissioner Ricardo Lara. Now, where AB 1642 focuses on who should set the safety standards, AB 1795 focuses on what insurance companies owe you right now and how the claim process should work. The DOI's support of this bill is notable for both good and bad reasons, in my view. Now, on paper, the bill says all the right things. It talks about science-based standards, protecting survivors, expediting claims, and creating a national model. It establishes the legislature's intent to create standards for smoke contamination, testing, remediation, and claims handling. And that's a fine goal. It's a good goal. Second, it includes an early action provision that would let survivors rely on local public health agency standards to support and expedite their claims. In theory, that means LA public health standards could help you today, except I don't know exactly what standards they're referring to. Third, it proposes to designate state and local agencies to implement and enforce the standards. And fourth, it's explicitly framed as trying to set a national model, the idea being that California can set the standards and other fire-prone areas follow. But what's the problem? Well, as I see it, the question isn't what the bill says, it's whether the bill will actually do what it says, and that depends entirely on who fills in the details. So here's the critical thing you need to understand about this bill as filed. It's a shell bill. A shell bill is a legislative container that has a title, a stated purpose, and an intent section, but the actual substance has not been written yet. The bill doesn't establish testing standards. It doesn't define what contamination levels are safe or unsafe, and it doesn't specify what restoration must include. It doesn't tell you when your home is safe. So where does that substance come from? Well, this is the area of concern. The press release tells us that the Department of Insurance Task Force will finalize its recommendations in March. And those recommendations, quote, will inform amendments to AB 1795. Now, that, in my mind, is a problem. because the task force's work product could arguably become the skeleton of this legislation. And that means the critical question is who fills the container, because who fills it wins. And right now, the entity positioned to fill it is the same task force that has been exposed as having multiple experts and lobbyists who work for insurance companies. No toxicologist, no independent scientific experts. So a shell bill is not inherently bad. It's a tool. But a shell bill filled with industry-influenced recommendations is dangerous because it gets the stamp of legislation and becomes very hard to challenge. Now, let me be fair about what's genuinely good here, because there is real value in the bill if it's done right. The early action provision is a fair concept. If it works as described, you wouldn't have to wait for a statewide regulatory process. You could use certain LA County public health standards, which exist, to support your claims. So you might be able to point to some of the notices that the Department of Public Health came out with last year saying that this stuff is unsafe, and use that to support your claim. The bill frames smoke contamination as a public health issue, not just an insurance coverage dispute. And that's an important shift. When it's framed as coverage, the insurance company controls the conversation. But when it's framed as public health, the science controls. It creates a legislative vehicle. A shell bill isn't just a risk, it's also an opportunity. Consumer advocates, your community, scientific experts can all try to shape this bill through the amendment process, if the process is open. And there's one detail worth noting. The bill includes other relevant scientific and health-based sources as input alongside the task force recommendation. So that provides a narrow opening, but it's an opening. It means that the bill doesn't necessarily have to be limited to what the task force produces. Now, I want to be direct about the risks because these aren't hypothetical. Some are already playing out. So the ceiling trap, what I call risk number one. Insurance Code 2071 already mandates coverage for all loss by fire, and your policy requires restoration to pre-loss condition. There's no magic number that defines done. That's frustrating, but it also means there's no numerical ceiling that the industry can point to. If AB 1795 codifies some specific remediation threshold developed by a captured industry task force, insurance companies will argue the thresholds define their obligation, both what constitutes a covered loss and when restoration is complete. Meet the new standard, claim closed, ALE terminated. Now, if that standard is designed to protect you, that's a good thing. But if it's a standard designed to create a floor, that's a bad thing. This is the single biggest risk. Risk number two is the task force capture. Multiple people on the task force primarily work for insurance company. There's no toxicologist and no independent wildfire smoke scientist. The San Francisco Chronicle article that came out, I want to say December 5th, confirmed these concerns. And in fact, I wrote the Department of Insurance a letter on November 5th, 2025, a month before the San Francisco Chronicle article was published. We asked for transparency and change with respect to the makeup of the task force. What we received was silence. If the task force's March recommendations become the skeletons of this bill, you're looking at industry-influenced standards laundered through legislation and stamped science-based. That's worse than no standards at all because it's harder to challenge. Let me talk about enforcement routing. Where enforcement routing comes up is enormously important. If it lives within the Department of Insurance, the same entity that convened the task force, you have a structural conflict of interest, in my view. If enforcement, however, gets routed to DTSC, that's materially different. If it gets routed to some other public health-based agency, that's a better thing. We want the standards to be written by agencies with scientific expertise and no inherent ties to the insurance industry. So where this lands in the final version will be telling. So neither bill as it stands today is a solution, but both are opportunities, real ones, if you all show up. AB 1642 has the right structure. It puts DTSC in charge, a real public health agency with real expertise. It operates independently of the captured task force. It treats your home the way the law treats every other contamination scenario. This is the bill with the right bones, in my view. Now, AB 1795 has certain visibility. It talks about early action, which sounds nice. Says all the right things in its press release. But as filed, it's a blank check. And if the wrong people fill in the details, specifically if the captured task force write the amendments, it could do more harm than good. Now, there's one world where these bills don't necessarily have to compete. They could potentially complement one another. AB 1642 provides the independent public health framework, the science, the standards, the agency authority. And AB 1795 goes to the claims handling overlay, the rules for how insurance companies process claims under the standards. Together, in a perfect world, they could be comprehensive. But that only happens if the community stays engaged, because the insurance lobby will absolutely show up. They have lobbyists. They have campaign contributions. They have relationships. They always do. And the question is whether we all will show up too. I want to close with something concrete. Your voice is the one thing the insurance lobby cannot buy. And here's how to use it. Contact your local assembly people, Remediation's office for one. Tell them you support AB 1642. Ask when hearings will be scheduled. Ask how you can testify. The bill needs vocal support. Second, contact Assemblymember Gibson's office, but with specific concerns about AB 1795. Don't just say you support it. Say you're concerned about the task force pipeline. Say you're concerned about the ceiling risk. Say that the early action provision needs mandatory language, not permissive language. Be specific. Give examples. Ask for when hearings are going to happen. Show up. Submit written testimony when the bills go to committee. Your stories matter. Your testing data matters. Your family's exposure matters. And the EFRU's data showing that the majority of insurance-backed remediation still tests positive for contamination is the most powerful evidence that Sacramento needs to see right now. Use it. File DOI complaints. Every formal complaint that goes on file makes it harder for the DOI to claim that the system is working. It creates a record. Even though I will tell you most DOI complaints aren't going to get you a resolution of your claim, it does help in the grand scheme of things. And finally, and I can't stress this enough, don't let anyone tell you this is settled. The press releases are designed to make you feel like someone is handling it. The task force announcement, the bill introductions, the commissioner's statements, they're all designed to create the appearance of action. And some of it is real, but none of it is complete. And the details that haven't been written yet are the details that will determine whether your families are actually protected. Show up, stay engaged, the outcome depends on it. I'll leave you with this. California law, Insurance Code Section 2071 already mandates coverage for all loss by fire. Your policy already requires restoration to pre-loss condition. The law is on your side. The only question, is whether Sacramento will enforce the mandate or whether the insurance industry will use this legislative moment to write themselves a shortcut around it. That's what's at stake. Not whether you deserve protection. You do. But whether the protection you get is real or performative. So show up, stay engaged. The outcome depends on it. Thank you.
Thank you so much. That was so extremely informative. So Dawn, I will kick it over to you.
Thanks everybody for all the questions. And there's, like Chris said, there's a lot. So I'm going to start with the most upvoted, which is basically about coverage. About does all loss include soil, HVAC, crawl spaces, attics, and how do we challenge unlawful policy exclusions?
Soil is a separate issue altogether because it's not considered part of the dwelling. So the coverage that says all loss by fire ties back to your property or your dwelling. So your soil is not going to necessarily be covered under that. There is sometimes coverage for trees, shrubbery, etc., but that's going to be a very limited coverage. Sometimes there is coverage for debris removal that can be argued that soil can fall under that category. And that typically actually happens with the total loss homes, because in order to rebuild, you have to first clear away all of the debris, including the foundation and whatnot. And so sometimes that contaminated soil comes up in that context. But soil is a harder issue when the home is still standing. Now, for a home that is so heavily contaminated that it has to potentially come down to studs and there's going to be debris removal there, maybe there's arguments that the soil can be addressed under that. But that's all I have to really say right now about soil.
Okay.
With respect to the other things that were brought up in that, everything is considered. Your HVAC system, your ducting, your attic spaces, anything that is within your property falls under.
Footprint of your home. So the dirt crawl space underneath your home would be included.
Correct. Yeah, it's part of the
Great.
it's part of the home, right? In order to remediate it. Yeah.
Great. ALE. So a lot around ALE. That has to do with insurance delaying, right? So the clock is running out and your checkbook on your ALE is running out. They're taking all this time investigating what actions can be taken when ALE has reached its either time or dollar limit, home is still unsafe, beyond filing a complaint with CDI, which we know is not getting really much action. What steps can people take?
Take legal action. The reality is that there is a broad body of law across the country that identifies when insurance company tactics or other things that are out of your control have delayed the process, that it should be a larger entitlement. And so, like, let's say as an example, your insurance company says, we're cutting off your ALE because we have determined that the scope of repair is X. But you are currently arguing that that scope of repair is wrong and that it's Y. And you've presented your own testing showing a much more thorough, extensive scope of repair is needed. Them cutting that off is improper and, in my mind, wrong, because there is a disagreement over the scope. And that needs to be worked through in the claim process. And if they refuse to do that and they terminate ALE prematurely, then that's wrong. In the sense where they've dragged their feet and caused your limits or time to expire, and your home is still not safe, or properly restored, then legal action will be your best recourse, because then under an extra contractual claim for bad faith, you can say that our home is still not safe. We can't afford to, or we need to live somewhere else. And those costs shouldn't come out of pocket. And you'll be able to seek reimbursement through the litigation process for any additional out-of-pocket expenses that you incur while your home is inhabitable because of the insurance company's conduct.
And for people lacking funds, there's different resources through the SBA, through FEMA. I mean, we have lots of resources on our website, but it's time to start looking outside for that financial assistance while you are going through this, because it's not going to be immediate for this, right? So I guess that goes into bad faith, which can be difficult to prove, right? If they're just investigating and it took time, or they replied to an email once every few months they can argue against bad faith, what have you. How do you prepare for, document, is there mass tort for bad faith, options maybe beyond litigation as well, tips and docs for building a case?
So, yeah. So, I mean, I think I touched on in large part during the presentation what the insurance company is obligated to do, which
Yep.
is to thoroughly, fairly, and objectively investigate your claim with your interests on equal footing of their own. And so when you see that they are not doing that, when they are only focusing on their interests, when they are focusing on self-serving evidence, when they are ignoring the evidence that you are submitting, when you have had to go out and hire your own expert out of pocket and they're not reimbursing you for it, and they are ignoring that evidence altogether and instead citing their self-serving biased expert report that tested for less, that
Yeah.
tested in less locations, etc., like that is where you start to see bad faith, right? As I tried.
How do you argue with them? How do you argue with them when they are going to take their experts over your own?
So the thing that you can do as a homeowner is you point out the evidence that you submitted. You point out any concerns that you have. So as an example, I was talking to a family a few weeks ago, and they said, well, my hygienist tested in the wall cavities, and my hygienist tested in the air ducts and found significant contamination and indicated that the air ducts and HVAC system need to be replaced and that the wall cavities need to be addressed, meaning that drywall is going to have to come out. And they said that the insurance company's experts didn't test in the wall cavities, didn't test in the air ducts, and their remediation method is a surface cleaning only. Well, so that begs the question. Excuse me, insurance company, the only expert to have tested in the air ducts and in the walls is my expert. And your methodology doesn't address the air ducts or the wall cavities. So how are we going to address the only objective data that demonstrate there's contamination in the air ducts and the wall cavities? That question is a critical one because how they answer that is going to be telling, right? If they don't answer your question, that's telling. And if they go, well, we're still relying upon our method, and they just dismiss you of your concerns of the testing, again, that's going to be bad faith. In a lot of these cases, the patterns that I've seen, the insurance company doesn't want to accept or consider the evidence that you have gone out and gotten on your own. That's bad faith. When they're not factoring in your health concerns, when you're writing letters explaining, my doctor is saying X, Y, and Z, and they say, we don't care or dismiss, that's bad faith. And there are legal processes to hold them accountable and to fully recover what you're entitled to under the law. Not only the contractual benefits, but what a bad faith claim does is it allows you to recover extra contractual benefits. So all of the other economic out-of-pocket issues that you have to deal with, if it's a loan, if it's taking money out of your savings, if it's having to go to a family member so that you can live somewhere else while you're trying to figure out how to restore it, or if you take out a loan to do the restoration yourself, all of that can be fully reimbursed under a bad faith claim. You're entitled to a certain amount of attorney's fees under a bad faith claim. You're entitled to recover for emotional trauma, for the anxiety of having to be put between a rock and a hard place. Do I move my family back to a property that I don't know is safe? Or do I continue to stay out here and drain my financial resources? That's not a dilemma that you should have to be in. The insurance company's obligation is to treat you fairly, honestly, reasonably, and with equal regard to their own. And when they don't do that, they expose themselves to bad faith, and you have legal recourse through legal action, right? You can file a legal complaint against them in court and hold them accountable. And it's great that LA County Council started an investigation into State Farm. I know that my firm is, we represent people in claims against insurance companies, and we're going to be pursuing claims against all the major carriers, State Farm, Farmers, AAA, you name it, because we're standing up for the community on these issues, and there's different ways that we can go about doing this to gain leverage, to push the envelope and gain momentum. And I won't bore everybody with the details here, but there are lawyers out there, such as my firm. My firm's not the only firm that do this. And if you are being mistreated and you're concerned that you've been running around sort of a path to nowhere for the better part of a year, then it's probably time to consult with a lawyer to understand, what your rights are. But the factors that I've described in the presentation today outline the bones of what a case, should be predicated upon. It's always going to rely upon evidence. That's number one. As I tried to point out in the Caribbean case, if you don't have testing, you need to get it. Because if you're only relying upon, well, my neighbor had it, so it's probably true that mine did too, like that's not going to work. You have to have objective, verifiable, independent data that supports what the extent of contamination is. And then the next step is having a construction professional review that data to evaluate what the proper scope of repair is. And obviously, if you have a medical person that has looked at the data, I know some people have taken their hygienist testing data to their doctors to weigh in and provide letters to their insurance company. And you better believe it. If you have a doctor who, based on your particular health issues, writes a letter that says they are concerned because of whatever the issues that you have are about the contaminants that have been found in the home, and they provide a medical opinion to that insurance company, and your insurance company ignores that, you better believe that that's grounds for unreasonable conduct.
Excellent. Thank you. And do you take on SCE lawsuits or just the insurance ones?
So my firm, I'm not involved in SCE lawsuits. My firm, I have partners that are engaged in SCE lawsuits. They're on the committee. I have other lawyers that I work closely with that are involved in it as well. I know my firm also is involved, not me, because I manage our insurance practice, but there are people that are doing the claims against, on the Palisades side against, the county, the city, the state, etc. So, to the extent that you haven't pursued a third-party claim for those responsible for starting the fires, that's something you should definitely consult with, because especially for people that are underinsured or uninsured, the third-party claim will provide potential assistance to cover gaps that insurance didn't cover.
And do you think that these bad good cases are going to settle in mediation, or do you think they're going to go to trial?
So, every case is different and unique. And so it's hard to say in the abstract. I think that the insurance industry right now as a whole doesn't want to accept the idea that the smoke contamination claims are real and legitimate and require full compensation. But as an example, we are engaged right now in the coordinated fair plan litigation, right? And so that process, everybody has individual cases against California Fair Plan. It's been coordinated in front of one judge. And what is going to happen is the case is going to move rather swiftly, more swiftly than a typical case in terms of getting certain discovery and getting certain issues. And so the case may be teed up for certain cases to go to trial before others, then use that as an exemplar for resolving the cases. And I can see that happening, with other carriers. It's certainly something that we're considering doing, is, bringing a number of verticals against the different insurers and trying to see if we can coordinate them.
Yeah, because a lot of the cases you cited did not favor the insurance companies. So you'd think that they would, presented with that, they would then settle.
Yeah.
Right. So I guess the more of them you have, the better.
I think the more people that are willing to bring actions against their insurance companies to hold them accountable, it will create momentum. And I think there will ultimately be, a positive result. For the more people that are there, the better, because then the industry realizes it can't just pick individuals off.
Right. What about contractors that are hired and sent out by the insurance company and keep the homeowner or the renter in the dark about the results?
That's a good question. So under Insurance Code 2071,
2071, ladies and gentlemen.
you are entitled to request all claim-related documents.
Okay.
And claim-related documents is defined in the code to include all expert type of reports that go to the issue of valuation and otherwise. And so, the insurance company is not the only one who gets to control the documents. So a lot of times I see people say, well, my insurance company gave me an estimate that was based on a contractor, but they didn't give me the actual contractor's estimate.
Mm-hmm.
Well, you're entitled to that actual contractor's estimate. That is not work product. That is not, attorney-client privilege or anything like that. That is a document that you are entitled to understand the foundation upon which the estimate that they are claiming, for your benefits are owed. You're entitled to that under the law. And so you can make a claim-related document request under the insurance code to obtain those documents where the contractor or other professional created an estimate. So whether it's an HVAC contractor, a restoration contractor, or some other professional, you're entitled to see that documentation. And if you ask for it and they refuse, right, that's other examples of unreasonable conduct.
Does that fall under bad faith?
Yeah. So literally bad faith is defined in the law as being unreasonable, right? Okay. So it's like if they handle your claim in an unreasonable way. And so the question is always, well, what is reasonable? And so that's why I tried in the presentation to go through some of the factors that the courts typically look at for what is unreasonable, right? An investigation that isn't an objective one, an investigation that isn't thorough, an investigation that isn't fair, when the insurance company is not putting your interests on equal footing, when they're not looking for coverage, but they're only looking for ways to minimize, when the insurance company is hiring experts that are biased, and when you present information to them and point out to them flaws in their expert's report or conflicting information that they ignore it. Those are all, telltale signs of unreasonable conduct that can be, defined as bad.
Great. Several upvotes on, is there a law to enforce demolition of a ultra toxic home where remediation cost is higher than a rebuild? I don't know. Sorry, that would be.
Well, really, the loss, the law is all loss by fire. It really comes down to what is the extent of it, and it's it becomes a battle of your expert is saying that in order to properly restore your home, it needs to come down to the studs, and the insurance company is refusing to acknowledge that. And so within the framework of the law, you would be saying, this is what my report shows. This is the extent of the contamination. This is what the construction professionals say is needed to put into work the testing scopes and ideas that the testing professional has. And if that means down to the studs, then that is the loss by fire that you suffered, that you are entitled to coverage for. And the insurance industry will come back and say, yeah, that's not right. Look what our expert says. Our expert says you only need to wet wipe it, HEPA-vac, and hydroxyl it and call it a day. That's the only thing you're entitled to. And that's where, unfortunately, litigation becomes necessary because that, in the claims process, the industry has all of the power. They control the timing, they control what happens and what's paid, etc. But you can take that power back in the legal process because when you file a complaint against them, now they have to respond. Now they have to act. Now there's a judge. Now there's a jury. They don't get to control it anymore.
Yeah. So a few people asking, how do you prove that the insurance company's expert is predisposed to favor them?
Well, if history proves, right? And so when you show that, and in the, it's obviously difficult in the abstract to say, well, I think this expert's biased. But if you look at who the expert historically works for, and in litigation, we're entitled to get copies of their reports in other cases. And so you're able to then demonstrate a pattern of conduct. So like, as an example, if every single report they write for an insurance company is to rebut homeowners, and every single report that they write demonstrates every single time, oh, it's just this minimal cleaning that's needed, right? The proof's in the pudding. And if you can show that they write that same type of report on every case, the ones where let's say you have a competing testing methodology that shows that remediate or that, that the contamination is extensive, and they write, oh, only this little bit of cleaning. And then you have one where the contamination is not so extensive, and they say, oh, only a little bit of cleaning, right? You can demonstrate that there's a pattern. There. And so, we run into a lot of these experts time and time again. The insurance industry sort of goes back to their Rolodex of the same players over and over again. The mere fact that the insurance industry uses the same expert over and over again doesn't mean that they're biased per se. Well, the way that you prove it is when you have objective, independent data reflecting significant, severe contamination, and they just ignore it. And they write a report as though it's a completely different property. And they do that time and time and time again. That's when you tend to see they're not looking at this objectively. They're seeing what they want to see. They're looking at it through a different lens. Another example could be when they refuse to do testing in all the same areas, right? So like if they're not testing the HVAC ducts, but you are, and you bring that up and they say, well, we don't test it. Well, why not?
Right. Background levels. They keep trying to throw the background levels. I know you address that, but anything further to say about that?
How are they going to prove that?
How to counter?
I would say this. The insurance company has an opportunity at the time that it underwrites the policy to do whatever testing it wants at a home. Exactly. It can come out and inspect your home. It can come out and test your home. It can say, as part of the process, that we're going to need to do a free test to see what's there, right? And if they didn't do that, I don't know how they're possibly going to prove that this is quote unquote background. I don't know. I mean, they tried to do that in the case that the Eighth Circuit Court of Appeals addressed that I talked about. I'm forgetting the name of the case now. It's like the Metro case or but in any event, like the background argument is something that they all try to argue, but it's always in the abstract. Oh, this is background. And they don't say what their evidence is to show that it's background or what the source is, right? Like I had a case last year. I kid you not. So the hygienist expert was saying that there were chloride anions found in the property, and that chloride anions are a byproduct of combustion, and chloride anions specifically affect electronics and cause them to fail on a much faster basis. Okay, fine. So the insurance industry expert goes, oh, but it might have been caused by the ocean because chloride anions can be caused by the ocean. It's like, really? By the ocean? Like, yes, the homeowner lived in Malibu, but how exactly did it get all the way from the ocean over here? Like, it's just absurd. When we had video proof that the flames were literally up against the structure. Mm-hmm. Oh no, it's not from the fire. It's from the ocean. Like these are the arguments that they try to make. Oh, it's from the fireplace. Oh, you mean the fireplace that they've never used since they've lived here? The one that's a gas burner and not a wood burner? Right? Oh, it's the barbecue. Like you just have to sort of like call out the BS and be willing to push back and press them hard on. Say, where are you getting this data from? Because a lot of times they don't. It's just red herrings and distraction and, smoke and mirrors, pun intended.
And I have another question about the bad faith. I don't know if I got the full answer. Can there be a class action on bad faith? I mean, I guess that's kind of what the letters are that we shared, right? Is to push that.
So it's not a class action because
mass tort.
So there are ways to coordinate legal action so that similarly situated claims are brought in front of a single judge to determine common issues of law and common issues of fact. So like, as an example, for the folks that have sued Southern California Edison for starting the Eaton fire, or for folks that are suing the county or city of LA or the state for the Palisades fire, right? Those are not class actions. Those are what are called mass torts. And really what they are coordinated proceedings. Everybody has a common interest in establishing that Edison caused the Eaton fire, or that these municipalities played a substantial factor in the way that the Palisades fire started. But everybody's situation is a little different, right? They have a different home, different losses, et cetera. In a typical class action, everybody's got the same damage. Like they all fall into the same bucket. And so one person can serve as a representative for the masses.
Mm-hmm.
Here, in a coordinated proceeding type situation, everybody would have to bring an individual complaint against their insurance company. And then there are mechanisms to try to get a judge to coordinate those cases together for efficiency. So like that's what we've done in the FAIR Plan litigation, is we told the judge, hey, there's all these cases against California FAIR Plan that relate to smoke damage. They all involve the same policy language, and they all involve similar claims handling practices. So rather than having different judges potentially reach different decisions on the same issue and lead to conflicting results, we should have it all in front of one judge. And so the judge in downtown LA agreed with us. And so we got that case coordinated. And so now we're going to be able to pursue both case-specific issues, but also common case issues. So like, FAIR Plan discovery that relates to their overall practices, or how they've come up with their insurance policy language on smoke, et cetera. And so the same can be done, potentially with other carriers. There's logistics that have to be gone through and whatnot, but there is the potentiality to do that. And it's certainly something that my firm is exploring and working on.
Right. And when somebody hires an attorney, and I think this is probably individualized, but what can people expect? Are they paid on percentage, hourly, that kind of thing?
Yeah. So, I mean, that's a very broad question.
I know.
People do things differently. What I can tell you is my firm is a contingency firm, so we don't charge by the hour. So contingency lawyers, like I'm sure many who have retained people for like Eaton fire cases against Edison, et cetera. So the way contingency lawyers work are you don't pay anything up front, or until a successful recovery is had. And if there is no successful recovery, you don't owe anything to the lawyer for the work. So the lawyer is taking the risk in evaluating the viability of the case. And so when I take on a case, it's because I think that there's merit to it and that there's value in it and that I can add value to it, because essentially I become partners with my client. Like, I don't get paid until my client gets paid. And so I'm completely tied to the hip and, in lockstep with the client. So that's how my firm handles our insurance bad faith cases. I think there are other firms that do that too. I know that there are lawyers out there that do it by the hour. I understand that families are hurting, and trying to charge somebody out of pocket by the hour doesn't make sense for most of my clients. That's why it doesn't work for my firm. That's why we exclusively do contingency litigation.
Okay, great. I want to wrap it up.
Let me drop real quick my contact information. So
Great.
So feel free, you guys can contact me, contact my firm. This is what we do. This is the type of work that we do. So we'd be happy to speak with you about your individual situations, if that's something that you'd like. I know EFRU also has my contact information. We want to be here as resources for you. We know that this is a very trying and difficult situation. So I just wanted to put that out there. The firm's phone number and my email address specifically. If you guys reach out to me, I promise I will have my legal assistant coordinate individualized meetings to meet with everybody. I do that for everybody that reaches out. This is a passion of mine to, find, comfort in understanding that you can breathe, that there are people here, at the EFRU, there are lawyers, there are other people who are champions and advocates to support the problems that you are facing. And I'm certainly one of them and happy to help.
Amazing. Thanks, everybody.